So, I'm going to welcome you to the Edge. And that means I'm hoping that my PowerPoint slides are miraculously going to appear, because this is still the break slide, I think. But there is secret communication. No, we don't want that. Yes, very good. This is the first slide. So welcome to the Edge. For those of you who don't know, I'm Mireille Hildebrandt. I have a research project. I'm principal investigator of a, as it is called, of a research project called Cubicle. And that's an acronym for Counting as a Human Being in the Era of Computational Law. And this is where this conference was born. Before going deeper into that shortly, I want to explain to you why we didn't put paper and pens and all in your goodie bag. But besides having this very beautiful t-shirt, we also added this duck. Now, my plan was to read this to you, so let's see how far we get, because I have very small letters here. So, yeah. So if you go, and I would really advise you, though some of you will be very familiar with this, but the lawyers amongst us probably not, to go to the site Rubber Duck Engineering. And you will find, as a start, this text, Rubber Duck Debugging. The Rubber Duck debugging method is as follows. It's very simple, it's 4 steps. 1, beg, borrow, steal, buy, fabricate, or otherwise obtain a rubber duck, bathtub variety. First step, already passed. Second step, place the rubber duck on your desk and inform it you are just going to go over some code with it, if that's okay. Step 2. Explain to the duck what your code is supposed to do, and then go into detail and explain your code line by line. We're already at step 3. Step 4. At some point, you will tell the duck what you are doing next, and then realize that that is not, in fact, what you are actually doing. The duck will sit there serenely, happy in the knowledge that it has helped you on your way. There's some more text there, I advise you to check it out. Now it's clear with us gifting you this beautiful little duck, VUB duck actually. It's a duck in the colors of this university. That CRCL22 commits to sentience. Let's be upfront about that. Not sentience of AI, of course, we're not stupid, but of the rubber duck. So that should clear the air at the beginning of this conference, and now we can go back to the serious business. So this is the front page of, and I'm happy you're smiling because you will need that spirit. I can assure you the rest of the conference will explain to you why. So this is the front page of our project. Cubicle stands for Counting as a Human Being in the Era of Computational Law. And in the context of this project, we also developed a journal. We initiated a journal. Co-editor-in-chief is Frank Pasquale. And I have some news about Frank, but I will share that with you later. He's going to do one of the keynotes, as you know, and he's also one of the general co-chairs of this conference. The co-founders of the journal are Lawrence Divier, who is on the front row, and myself. And the idea of this journal is that it's different from other journals. So we have papers coming in from the side of law and the side of computer science. And after a paper is accepted, after double-blind peer review, so that's like all papers and all journals, we invite somebody from the other discipline. So law papers, we invite a computer scientist, we invite a lawyer. And there is also important space for social science and humanities input. We invite somebody from the other discipline to write a brief reply to the main text. And that is the core of cross-disciplinarity. So everybody likes to talk about interdisciplinarity and then unfold ideas about developing a shared vocabulary. But we are not doing that. What we are doing is saying it is very important that lawyers understand the language of computer science from within. I'm going to give you one example. When a computer scientist speaks about optimization, the meaning of that term is mathematical and very precise, and they're very aware of that. If somebody else hears that, like a lawyer or a social scientist or an ordinary person, the persons that matter for the law, they might hear something entirely different. Or, for instance, an economist might be hearing something different. And it is key that we learn to understand precisely what these sort of terms do. Not just what they mean according to some dictionary, but their function within machine learning in this case. So this cross-disciplinary conversation is key to the journal. Main article, reply, response of the author, very short. And the idea is that, and you should try it out because we have a lot of online first publications out now. You should try it out and you will see that the conversation that is after the main text is very interesting and totally different from what you will find in any other journal. Now, this is also how the conference is set up, as you know. The format of the conference is based on the same idea. But let's first praise all the people that put a full year of very hard work into this conference. First of all, my general co-chairs, Katie Atkinson, maybe you can just stand up? Yes, fantastic. Frank Pasquale, he cannot stand up, and I will share with you that he was supposed to land in Paris this morning, and I received an email from him at 3 o'clock in the night that he was still at the airport in the United States. And after many delays of his flight, they had canceled it altogether. And since it's a sort of small boutique airline, they could not offer any replacement. So he had to travel back, and that means we have to swap keynotes. He's going to be on remotely. But so he is both co-editor-in-chief of the journal and general co-chair of the conference, and then Lawrence Diver. Maybe also you could stand up so that everybody has seen you. And I think it is important to say that all the work on the back end of the website, so the website of the Cubicle project, but also the Easy Chair system and everything, this is what we owe Lawrence, who in another life that he lives simultaneously maybe is also a web designer, has been, had his own company, right? Then we had track chairs, Lyria Bennett-Moses. I can ask her to stand up, but you won't notice because she's in Australia. And Dennis Merigou, maybe also you could stand up for a minute. They were in charge of the track formalization and rules of code. Harry Surden, I could ask him to. Yes, thank you. And Sophia Dolede, she is not here. Fleur Johns, also in Australia, and Jatinder Singh. Harry and Sophie were in charge of legal search and prediction, so prediction of judgment and all the legal search that's going on. And Fleur Johns and Jat Singh is also with us, please. They had the track of AI and international law. And as you might see, this is pairing of lawyers with computer scientists, teaming up, looking at the paper. Basically, any paper that comes into their track, which is written by a lawyer, is checked or handled by the lawyer. A paper that is coming in from computer science is handled by computer scientists, because we believe that peer review should be done by your peer, by somebody who knows, has the background of your own discipline. During the conference, it will be replied from somebody from the other discipline. Okay, so we also had a program committee with a high number of anonymous reviewers from both law, CS, and social science and humanities. And they worked all through the summer to make sure that we could make the right selection. Again, about the conference, what is key to the conference is, of course, that it was funded by my ERC grant, but in that way also by the two universities, the main host institution, that is this university, and my other university, Radboud University, where I have a chair in the science department with the computer scientists. And I have to name and call out the entire cubicle team. So this is two teams, computer scientists and lawyers, who have been working for the past nearly 4 years on this theme, and in that context also co-organized the conference. So that's again Lawrence Diver, Zara Dushi, Jamarco Gori, Pauline McBride, Masha Medvedeva, Arjun Banerjee, Tatiana Duarte, Emily van den Hoven, and Paulus Mason. And then last but not least, Irina, who's not here, but somewhere else. She's our project leader, and I could say that between Lawrence and Irina, anything in this conference that goes well, we owe to them. We shall not put blame on anything that goes wrong. Quickly about the edge, it's an interesting question, so welcome to the edge. What edge? Are we talking about a cliff? Are we standing on a cliff? Are we standing before an abyss? So we're on the edge of a cliff and we're looking down into an abyss. And is that abyss something that we are rushed into? A kind of algorithmic law that freezes the future by scaling the past. And the argument would be that machine learning, if you use that to predict things, cannot be trained on future data, but only on historical data. That means you are going to assume that the future is like the past. And if you make your decisions based on that, you might actually freeze the future. But maybe this conference is about asking the question, could we fly? And actually, I'm now borrowing the words of our former rector, Caroline Pauwels of the VUB, who said, if you encounter a situation where you are afraid to fall or to fail, and you don't want to take the risk, sometimes you have to ask yourself, what if I fly? Okay, the conference ethos. This discussion about, is this about the future of law or is it about the end of law? This conference does not take a stand on that. It says this is not an abstract question, but an empirical question that has to be based on how these technologies are actually designed and developed and deployed. That means we're not into legal solutionism or legal skepticism. We want to steer free of any ideological entrenchment in that way. So we're going to do, when we're talking about the papers, we're going to do slow science. So that means there will be a paper presentation by somebody from either law or computer science, and some of the papers actually already combine that, and then a replier from the other discipline. And after that, we involve the audience. I'm going to ask you, so I'm going to be moderating that. I'm going to ask you to put up your hand if you have a question. I will note it down and give you turns in sequence so that we don't have a sort of discussion, yes, no. So if you put up your hand, you're going to get a turn and you're going to get a space to really ask questions. In the meantime, we have a large online audience, probably about 150 people, though we know how it is with people who register, so maybe it's about 100 people. They can also raise questions in the chat. They will be monitored and filtered, so they will also come into the audience, into the conference. What are the objectives of the paper presentations and actually of the conference? It's to learn. To learn about the perspective of the other discipline. And in the end, the objective is to learn how to assess downstream effects of computational law, of design decisions taken in the context of building that law, downstream effects on real people. And that means for us, key is what is this going to do to the rule of law and legal protection? This is today's program. So the first thing you already know, Frank Pasquale's keynote tomorrow morning is swapped with my own keynote. He will present at the end of the day because he will be in the United States. And since things that go wrong never come alone, I think 1 hour after I received his email, Virginia Dignam, who's going to speak now, told us that she is in the midst of a tropical storm in Indonesia and has no electricity. That also means that I could take a little bit more time because I'm going to speak myself. So I've swapped with Frank and now I've also swapped with myself. As you understand, this is an extremely flexible conference. Being very flexible is only possible if there are some clear rules. And one of the questions is, we have large coffee breaks, about half an hour, to really come back in time because people will be sitting in Indonesia or elsewhere to present, and we want to stick to the schedule because it's a hybrid conference. So now this is the end of my introduction, but clearly this is of course actually the beginning. And that means you're going to have to listen to me a bit longer, actually for another 50 minutes, and I assume that we're now going to have the second PowerPoint. And I also hope you understand that this keynote was written to be at the end of the conference and not at the beginning. And I hope you appreciate that I would not have done it like this. Besides that, it's not really entirely finished because I thought it's nice. I have 2 days to tune it. And to make sure that I connect with you, with the audience, because that's expected to have had questions. Well, I'm very sorry, but that's not going to happen. So, computational law on edge. I'm going to try and speak a bit like this because it's easier. I can see what I'm going to talk about. I'm going to ask the question, what is law? And that's strange because we sort of assume that we all know what's law, and now we want to talk about computational law. I don't think so. Because for lawyers, law is so evident, it's like the air we breathe. Or the famous story about the fish that is swimming. I don't remember the exact details of the joke. You can look it up or somebody else will tell you over coffee. That doesn't know that they're swimming in water. Because it's there, it's like our air. So the question, what is law, for lawyers may not be very relevant, but if the nature of law is going to change, it might be very important to raise that question first and then ask the subsequent question, if that is law, then what is computational law? What is the edge that we're talking about? And then look into risks and possibilities. So let's first talk about what is law. And maybe it's fun, but there's a famous German legal historian, Uwe Wesel, who did a lot of research not only into legal history before the rise of the state, so let's say the low Middle Ages, and also did a lot of research in anthropology, so into societies without a state. And he said, defining law is like nailing a pudding to the wall. Well, good luck. To cut a very long story short, Because if you try to nail a pudding to the wall, we might spend the entire 2 days trying to do that, and still it will blubber down. So I'm going to take a famous legal philosopher, Hart, and he said, he acknowledged this. This is actually, you can't define it, but there are always 3 questions that must be answered to really understand the law. Is this better? Very good. This is what professional support does for you. Thank you. There are 3 questions, and those questions were also very important for anthropological and legal historical research. So if there is a society where the difference between religion, politics, and law basically doesn't exist, does it make any sense to talk about law? And if not, then at what point do we speak of law? And you can see from the first question, what is law other than an order based on orders backed by threats? The second question is, how does a legal obligation differ from a moral one? Once again, in societies without a state, that difference is not obvious. People don't think in terms of that difference. And the third question is, what are rules? And to what extent is law a matter of rules? And these are absolutely key questions, and they're also very relevant for the question of what is computational law. So the first question is, how does law differ from orders backed by threat? He is trying to reject the work of another very famous 19th century lawyer, legal philosopher, Austin, not to be confused with the Austin of Speech Act theory. And his theory was basically that law is about orders, a set of orders backed by threat. So the monopoly of violence defines the law. If there is somebody who can grasp that monopoly, they can impose general rules, and here we have law. He is basically not going into details about exactly what Austin wrote. He's saying, I'm going to target how Austin's ideas are basically defining what many people think is law, by saying that it is just about orders and violence, actually, then. And he has 4 arguments why it is not the same. The first is that legislation, and he's of course thinking in terms of a democracy, a constitutional democracy, legislation is not an order because it applies to those who give the order. Second, legislation is not just about subordination. It's not just orders, it's very much standards. So whether we all drive left or right is not a moral question. Actually, it doesn't matter at all. It's a coordination norm. So when you violate that norm, it's not that there's something inherently better about driving right, though I'm sure some people think so. We can all agree that this is about coordination. Many of the roles in a legal system are about that, so that we can anticipate how others are behaving. Third, many laws do not only impose obligations, but also attribute legal powers. Now that goes even a step further. So it's not just about coordination. New ways of acting are created. So we can conclude a contract. And when I do that, I can be sure that if you don't perform, I could go to a court. Now many people think that comes from Roman law. Not true. It comes maybe from the reception of Roman law in the late Middle Ages. Pacta servanda sunt. That's Latin for you have to perform your contract. But in the Roman kingdom and in the Roman Republic and in the Roman Empire, there was no such rule. There was no such rule. You could not go to court. There were specific contracts that gave you an action, but the general rule was not there. So what I mean with attributing a legal power is that when I conclude a contract with you, I now have power over you. And that power is not about violence. It's not an economic power. It's something that is up in the air. We have all agreed together, and that agreement sits at a high level of abstraction. Nobody went and asked everybody, do you agree with Article so-and-so of the Civil Code? This is the social contract. We have agreed if you conclude a contract and it's valid, then ultimately you can go to court and you can get it done. So that's concluding a contract creates legal powers, and they are real powers. Try to think that this was not the case. Your life would be totally different. Buying things, buying houses would come to depend entirely on your ability to show your economic or even physical strength with regard to others. You get a totally different society. So the law creates things. 4 laws more than enacted law, so the law that the legislator writes. It's also about custom and principles, and these actually bind us. This is not a soft law extra. They actually bind, and they usually determine the interpretation of written law. So this is extremely important. So he says, okay, now we're clear. Law is not, cannot be reduced to the command theory of law. Now, what would this mean for computational law? First of all, it assumes that law is always contestable, even against the government, in an independent court. So if you are going to write a type of computational law that is self-executing, for instance, you're going to miss all that out. So based on that, we would say that's not law. It's like administration, automated decision-making. Maybe that's fine, but it should be under the rule of law. And then you have the contestability. Legislation is not just about subordination, but also about coordination. That means that law functions as a standard rather than a computational rule. It's not about calculation, but about judgment. There's a famous book by Brian Cantwell Smith, The Promise of Artificial Intelligence. He is a computer scientist. He's also a philosopher. And the subtitle of his book is Reckoning and Judgment. And he's saying what computers can do at this moment, including deep learning, neural nets, GPT-3, etc. That is reckoning, that's calculation. It's next word guessing, basically, if you talk about GPT-3. There's nothing, it's huge, you need to train on a lot of data, but for the rest it's just a trick, a very smart trick, but nevertheless. So it's not about judgment, and developing coordination rules requires flexibility. People must be able to, in changing circumstances, adapt their behavior to this norm, and that cannot therefore be a computational rule. Of course, you can use a computational rule in terms of administration, but that is then something that should be under the rule of law. Many laws do not only impose an obligation, but also attribute legal powers. Now, this is connected with Speech Act theory. So if I'm a civil servant and 2 of you come in front of me and have prepared to get married, all the conditions are fulfilled, and I'm standing here and I say, I declare you man and, well, let's say man and man, husband and husband, whatever. And in continental systems, if I register that statement in the registry, then from that moment onwards, you are married. I did not cause your marriage, right? I hope not. And it's not that I invented reasons for you to be married now. So this is not about causality, and it's not about reasons. This is a constitutive act. You do what you say. Me saying you're now married is not a description, it's an act. Now that's what the law is about. It acts. And it would be very difficult to imagine that for something like the outcome of computation. There is no speech act there. We can attribute legal effect to that, but then the speech act is ours, not the system's. Law is more than enacted law. There's a lot of unwritten law, where we have to remember that any lawyer knows that that unwritten law determines the meaning of the written law and not the other way around. This assumes that law is not just about formal rules. Formal rules require disambiguation and closure. The idea is that a legislature enacts rules and does not get the last word on the meaning of those rules. So the legal rule begins to coordinate human behavior. And in that practice, it acquires its meaning. And in the end, it's a court who then provides closure and decides the meaning. And maybe 10 years from now, another court will, based on changed circumstances, make another decision. Okay, now let's look at the next. Is a legal obligation, is that actually a moral obligation with some force behind it? Here Hart argues against natural law theory. So he says law does not only prescribe, prohibit and permit, but also, and here we're back, I can go fast, it attributes legal power, it creates things. Legal norms do not necessarily express moral principles because they often coordinate. Here we're back again. Legal norms have legal effect, and this effect is performative. So when we conclude a contract, something changes in our shared reality, and that change is real. It's not softish or something like that. You're going to pay if you don't perform. So legal norms have legal effect. It is performative, as it decides what action, event, or state of affairs counts as what. So what does this mean for computational law? Well, it assumes performative speech acts which cannot be given by a computer. So we can attribute legal effect to the output of a computer, but that is our decision. Legal norms do not necessarily express moral principles. Take the example of driving left or right. And back again, the difference between rules and standards. This is a typically United States difference that is made. So a rule is binary and quite formal, and a standard is more flexible. Legal norms have legal effect. This effect is performative. Again, this assumes this legal effect. It's coming back all the time. The term legal effect is key here. Now, the last question. To what extent is the law a matter of rules? From a computer science perspective, it might be interesting to assume that law is a matter of rules, similar to the kind of abstractions that are the target of the building of computational systems. Now, here, basically Hart is arguing that saying that it is a matter of rules, you must first answer what you mean with the term rule. So here he is saying rule of law is not about any type of rule. And it certainly doesn't mean that there is a kind of arbitrary power to enact whatever rule those in power see fit. So law binds based on interlocking set of primary and secondary rules, as Hart famously said. Primary rules are prescriptions, prohibitions, and permissions. Regulative rules, Kant would say. So you're not allowed to do that, you have to do this, and you're allowed, but you don't have to do this. Now, the difference between a moral system and a legal system is the secondary rules, because that's about the attribution of legal powers to create rules that then bind, to change them, or to decide on their meaning, like a court does. So the secondary rules are what Kant would call constitutive rules. And you could say they're the rules of the game. They determine whether a primary rule is valid or not. And this interplay between primary and secondary rules, Hart says, that is what law is about. If you don't get that difference, you don't understand the law. It'd be very interesting to hear about how that relates to computational law. Legal concepts that are part of legal rules have open texture, which basically means they cannot be formalized. You could say, of course they can be formalized, but never completely. By formalizing them, you're restricting them. You're basically, in a sense, denaturalizing them and then turning them into administration, which might be good, as long as you label them like that. Now, how does that relate to computational law? This is key to this conference, but also to everything that is done with computational law. This is key. So you have to assume a specific understanding of what is a rule, to understand what legal rules do, because legal rules do things. And I would say that the best way that has been framed, this type of rules, is by Wittgenstein, famous philosopher, in his work on philosophical investigations, so not his Tractatus, and Anscombe, who was very familiar with both Hart and knew the work of Wittgenstein. So how does this relate to the difference between primary and secondary rules? Well, primary rules, you are not allowed to kill somebody, providing some constraints, if you self-defense and everything, we know. Or you have to go to school if you're not yet 16. Or you are allowed to start a business, but you don't have to. So these are the three types of primary rules. When you look at rules like a lawyer does, then it's both more and less than logic. Of course, to explain, to justify a decision about what is the law, you will need to use logic to say, okay, this rule applies, this is what it means, these are the facts, that means that is the conclusion. But within the law, everything that matters is in the decision, which rule applies to this case, whether it does, and what exactly it means in the light of these facts, and how to qualify these facts in light of that rule. So the syllogism is a justification. It comes at the end of the process. It's a check. It constrains the decision space of the judge. But the real work happens elsewhere. Well, legal concepts have open texture, so they cannot be formalized without denaturalizing its scope. And that assumes that interpretation cannot be frozen at the moment that you enact. The whole idea of these rules is that they are living, that they are alive, that they actually coordinate human interaction. And since the future is not the same as the past, as we all know, those rules have to be adaptive. So if you try to foresee all possible cases and then write that rule down in a self-executing way, or in a way that automatically makes decisions that are then taken over, you have basically frozen that rule and thereby also violated the distribution of powers between the legislature, the administration, and the courts. So to understand what is law, we need to understand that law is not information about something. When we talk as lawyers about the sources of the law, these are the sources that define law, that determine what is law. Basically, it is a set of interrelated, nested, and interacting rules. This is very important. So you can take one rule, take a dictionary and say, okay, let's disambiguate it and then formalize. That has nothing to do with law, because that one rule will have to be understood in compliance with human rights law, for instance, with constitutional law. And it will interact with, for instance, if it's a law, an administrative law, it will also interact with private law and other things. So And all these rules, when they interact, every time a decision is made, they slightly change their meaning. Yeah? So these rules, they inform, they are not about information about. Yes, that's interesting, you need a lot of information about. But what lawyers do when they have to solve a case, they look at the sources of the law, and they have to know what informs that decision. So that's about which rules bind those who share a jurisdiction. So there's no global, universal law. That doesn't exist. We are democracies. We decide which laws bind us. That also means that solutions in one jurisdiction cannot be transported to another one. And of course, this is all about the fact that when a decision is then made, it will have legal effect. And basically, that means law is about doing things with words. Now, this kind of information refers to, I already said it several times, the sources of the law. Those sources are limited. It's not information about the sources. It's the sources themselves, the constitution of a jurisdiction, legislation and case law, fundamental legal principles, doctrine, and customary law. And very, very important, their interrelationship. The lawyers here, and maybe some of the computer scientists, know about the famous Austrian philosopher Kelsen. And he would say, well, this is a pyramid. We have the constitution on top, and then, depending on common law or civil law, we have legislation or case law, and these other things. But that's a simplification, and a dangerous simplification, because the hierarchy is not so simple. The different rules are interacting with each other, and they are interacting in different ways. And why can't you do law by writing a very smart software program that figures things out for you? Because you really need those 4 years of hard work to begin to understand how these rules connect with each other. Because law is certainly not about, oh, well, it's all very vague and let's see, and it depends on the circumstances, and I think this and you think that. No, one of the central values of law is legal certainty. Legal certainty. And precisely because of that legal certainty, disambiguation is dangerous because it makes the rule stuck to the past. You need to have a rule that is flexible enough, but of course not completely flexible. And that's very hard work. Okay, so the sources of law are not isolated chunks of information about the law, as in law as data. They are also not isolated if this then that rules, as in law as code, and I'm simplifying now, so you're going to come back to me and push against me and say, Mireille, yes, I already got my first question. So interpreting a particular rule, any particular rule, always requires taking into account all other relevant legal norms. And the question which ones are relevant does not have an obvious answer. Note that a rule cannot interpret itself, neither in data nor in code. Deciding the meaning of a legal norm is a speech act, and that requires judgment. Note that a legal rule is not the same as its expression. And I owe this to one of our postdoc researchers who is, alas, ill. But I hope he's well enough to be with us in virtual space. This insight, that a legal rule is not the same as its expression, does not only have consequences for computational law. It also means that when I write it down, that the rule is not what I've written down. And written down is an expression. But the rule itself is what orders our interaction. That's, I think, a very important point, because the consequences of understanding that are enormous. So we're not only talking about that expression in code or data, is not the rule itself, but also natural language. So the rule is part of a practice. It's instituted with checks and balances. It's not just any practice. Right? We're not doing relativism here. This practice matters. It's what protects us. Look at failed states, how people suffer. So the use of the rule basically determines its meaning, one of Wittgenstein's points. Though not just any use by anybody at whatever moment. That's precisely why we have law. That not somebody who happens to be in power can say, well, you know, I'm very intelligent. I read Wittgenstein. The meaning of this rule is in its use, and I'm going to use it like this, and you're going to jail without a trial because, well, it happens to be that I'm in power. Yeah, that's not law. That's another type of rule. Rule of law is about the attribution and institution of roles, relations. That means countervailing powers. And another important point, rule of law is not about self-binding. In German legal theory, there is a whole school, formal conception of the rule of law that says, yeah, the rule of law is very good. It means that the government restricts itself. Whoa! It has nothing to do with the rule of law. If we're going to depend on whether the government is so kind as to restrict itself, we're not in a good place. So the whole idea of the development of the rule of law, Montesquieu, basically 17th, 18th, 19th century, was to say we don't want to depend on that. We need countervailing powers. Okay, well, we'll do the rest in 5 minutes. What is computational law? I'm going to rush. Law is not computable, because that would denaturalize the law. Open texture implies that it cannot be formalized. That's the ground I stand up on. Others can have other views, of course. But now comes, it can be made computable. Of course it can. It's not computable in the sense that you can completely compute it, but you can compute it. Of course, people do all the time. That's what we have a whole conference about. So if we acknowledge the first point, this need not be a problem. Though we should avoid, of course, the reflex to make everything computable. Why should we make everything computable? Let's think about that. Now, law is not computable. It can be made computable, but it can be done in many different ways. And that difference matters, and that is what this conference is about. And I refer to one of the founding fathers of cybernetics, who's, of course, you know, cybernetics and AI are two schools that are at war with each other, but they are also very much connected. Bateson, and he said, living entities or intelligent agents are those that are able to make the difference that makes a difference. So we are flooded with differences. I see many different colors here, many different faces. If you would sit still and just try to imagine the amount of differences that you can perceive, impossible. But key is which difference matters. The difference that allows you to survive, that allows a society to flourish, etc. So the point is not difference. Difference is there always, but the difference that matters. So in this project and in the conference, we have a working definition. This is not meant in any essentialist way. Between code-driven law, all systems that do not learn. Let's put it that way. And we also put dedicated domain-specific programming languages under that. Data-driven law is all systems that learn based on training data. And we also put training data sets under that. You can also make other distinctions between legal search, Westlaw, legal intelligence in the Netherlands, case text. This is basically no longer doing just queries, so you put information into a data set so that you can retrieve it, but to say, no, I'm going to look at the connections, the patterns between these data. And if they are non-trivial, these patterns, then I might be able to learn something from that. So from query to knowledge discovery in databases and machine learning, watch out for spurious correlations. The more data you put together, the more spurious relations you get. Predictive technologies, think of the work of Katsaletras Galdikis and Masha Medvedeva, who is with us today. Natural language processing, artificial neural networks, deep learning. One of the dangers there is data leakage. Another distinction, another type of computational law would be representing, drafting, and executing legislation. For instance, blocks, Catala, logic programming, Leos, en regelspraak, specific, domain-specific programming languages. Think of Prolog, for instance, logic, declarative programming, solving the problem of ambiguity or reducing it to only intended ambiguity. Now, what's the difference that makes a difference here? Natural language and the open texture of legal concepts keeps legal norms adaptive, ambiguity and vagueness as features instead of bugs. Though that inherent flexibility and the discretion that it generates is not equivalent with arbitrariness. That's something entirely different. Under the rule of law, discretion implies normative constraints. Another difference is interpretation. So in law, you interpret the norm in light of the facts and the facts in light of the norm. That is possible due to legal imagination. Imagination, of course, is something entirely different from prediction. Prediction is based on extrapolation of patterns detected in historical data. It has to assume that the distribution of future data is the same as that of historical data, otherwise machine learning won't work. You have to make that assumption. It's a very pragmatic assumption, and we all know it doesn't fly. But for pragmatic reasons, it might be helpful. But of course, the question whether the future is going to be like the past is exactly the question we want to answer. I'm going to skip and move to the end because I want to be sure that we have questions. We can talk about the edge in terms of edges and nodes, the graph model. For instance, you could do a visualization of case law citation networks. We all know that as scientists, there is this scientometric network where our output, as it's called, is metricized. Now, you could do the same thing with case law and make a graph where the nodes are cases, decisions, and you look at how these decisions refer to each other. So the court says, as we said in that and that, or as that court said here and here. You can visualize that, then you have a beautiful graph story. You could also do a visualization of the evolution of statutory networks. So laws that are interacting with each other, referring to each other. How does that happen over time? Yeah, let's skip this one. Well, some people say that legal texts have many investors. We're talking about billions of dollars or euros at this moment, but very few users. So lawyers are still very, very careful. This is a very interesting point. So yes, the legal tech market is a bit edgy, and we have done our homework, we in the project, and looked into legal text. There's a lot of overblown promises and underwhelming functionality. We'll come back to that later today. Of course, the law is a public good in many senses of that term. It is what defines economic markets, the political realm and their interaction. Some people think that the law is determined by economic forces. The economic market is first established by law. And then, of course, the interaction begins. Now, let's try to invest. I'm ending on a positive note. This was supposed to be the end of the conference. So let's invest in good, appropriate, and cutting-edge use cases. And with that, I mean, let's figure out what sort of problems do we want to solve for which computational law might help. And I'm very quickly going to rush you here. Okay, very fast. Mixed method in legal research. So testing where legal texts fail. And to do that, so you take a legal text, you go and check and look where exactly it fails. So for instance, because of data leakage. And you take that failure as the interesting point. So you elicit objects of qualitative research, legal research, using machine learning, for instance, to see where that machine learning doesn't work, and to say, okay, that's where we need qualitative research. Taking falsification serious. So it's always about verification, but in science, verification basically doesn't mean anything. We only have a scientific theory if we can draw hypotheses from it that can be falsified. If you cannot do that, you're just trying to suit yourself. So verification is not a very scientific approach. Two examples, the thick machine. This is not about law, but it's an example to do what I just said. So you're going to test what a particular machine learning system gets wrong, and you're going to then focus with your qualitative research on what makes that obviously interesting that the machine doesn't understand it, doesn't get it right. So you could also, as I said, detect legal references to focus legal historical research, develop alternative framings of diffusion in comparative legal history. So that's a very compact sentence. So what if you want to know how certain ways of referencing, let's talk legal history, to Roman law have developed or in the course of a century? You could use machine learning for that. So checking out, using NLP to find out in historical court cases, this is 16, 17, 18, and I think 20. So they did a network analysis to see how the evolution of courts referring to certain cases, and this was actually a reference to Roman law, which was then partly still in force. Reception of Roman law. Okay. And you could do a similar thing with, this is a look at the evolution over time of statutes, both within Germany and within the United States, to see how these statutes evolve. And of course, in our journal, Simon Deacon and Christopher Marcoux did a similar thing, trying to use machine learning not to predict court cases, but to look back and to say, can it help us to figure out things that we could never do by sitting down and going through all this data? So I'm ending on a positive note. I'm giving you also an example of a text that was published in our journal. And here you see, so Simon Deacon and Christopher Marcoux are two lawyers. They basically present a way to use machine learning for doing legal research, and they are now replied by a computer scientist who is basically saying, be careful what you opt for. That computer scientist happens to be in the room, and she will speak to us later. And that means we now have 2 minutes, but as I am the chair also, I'm going to abuse my power and steal a little bit of the coffee break to take, let's say, 2 questions here and at least 1 question of the chat. I already have 2 questions, okay. Maybe the person in the back was first. We're extremely procedural here. Yes, and if you could please tell your name, because when I moderate, I will write down your name in the sequence so that I can address you. Otherwise, I have to say the person with the blue vest who is sitting on the third. Yeah. Yes.
Hello.
Yeah, I hear it going on. Yeah.
Thank you. So I might have completely misunderstood you, but
that would be great.
You seem to defend that, of course, legal rules and law is performative because it has constitutive legal effect. And you say, code cannot do that. But it seems to me that code has a lot of effect, constitutive effects to the real world, and might even have legal effect. Because it makes imputations. This is a case of that. For instance, with the Dutch child benefit scandal. So this is fraud. And of course, the wording is not in the code, but how the code is used. So how am I misunderstanding you?
I'm very grateful for your question because, I've said a lot and it's very easy to get confused. So if a civil servant takes a decision, that's an administrative decision, and that person could outsource that to an automated system that's happening every day, and then the law could attribute legal effect normally to that civil servant, and we have case law in the Netherlands where it says, well, if the administrative body that is responsible thinks that system is okay, then we consider that a decision of that body, and we attribute legal effect to that. There's absolutely no, I think I've said that 3 or 4 times. But that's administration. That's not law. That's in the realm of, let's say, the application of the law. So the law that I'm talking about is something else. And if you forget that, then you are talking about rule by law. And the difference that you touch upon is extremely important because the argument that you give is going to be given every day 20,000 times. But administration is not the same as the law. So I'm saying that the legal rule that is expressed in natural language, it might be expressed in code, that is what matters. And then I'm actually saying what we have to look at is what happens if you move from expressing that rule in natural language, giving that binding force based on which somebody uses a system, blah, 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 your example, and saying, okay, now we're going to write, for instance, the law itself in computer code and give that legal effect. That is possible. The Speech Act then sits with the legislator. And I'm saying that will make a difference, that makes a difference, because the way those rules operate are very different. So that is my point. Precisely, so you will see that when we talk about computational law, we often put law between inverted commas. And this is the key point. Maybe 10 years from now, nobody will understand your question anymore, and nobody will understand my answer, because it will be done. And basically, I'm saying that would be a very bad idea. And I'm also saying if you separate the two, if you keep in mind the legal rule is not what that system does, that's an attempt to apply it, that's a sort of a tool. But that tool has impact. And as you say, it has enormous impact. So that's why we have to think about this. So I'm not saying that these tools don't have even constitutive impact in the sense of if you have a self-driving car that decides whether you're allowed to sit in it, that's constitutive. It determines whether or not you can ride in that car. But it's not a performative effect in the sense of Speech Act theory, of course. It's a very different constitutive effect. And I agree with you, technologies have constitutive effects, but they are incomparable to performative aspect of a Speech Act. And these Speech Acts, I'm sorry, but ultimately they are going to protect us. And the decision, what gives us, what is allowed to rein in our interaction, that is a decision, that's in the end, of course, a political decision we will have to stand for. And I think we can spend 4 coffee breaks discussing this further. Second question.
I'm Maurizio Paraton from University of Pescara. I am a mathematician, so forgive me if I have. Could you put back the slide number 16, please? And first of all, thank you for your astonishing
We need more Italians.
Number 16.
They start with saying it's beautiful. I love that.
So this open text tour can just understand. Here you say, slide says that the law can be formalized, but it can be made computable. I mean, by formalization, probably the meaning we are giving to it is just like a decision tree, just a set of rules that we apply in this kind of way.
Yeah.
Slide number 19. And then we say that with natural language processing, natural language can be used, NLP can be used to somewhere the word NLP.
Oh, sorry.
Okay, the fact of the prediction, the slide with the prediction, maybe number.
I think
Okay,
it's
anyway,
another slide.
somewhere, we say that natural language technique in artificial intelligence can be used to make the law computable, and somewhere that we can't use machine learning because standard hypothesis in machine learning is assuming the future is distributed equally as was in the past. Can we think about a system of general artificial intelligence where there are judges and lawyers which are artificial entities which can learn things from text just like a human would do, and use these things to interact with the human in the loop system, a very complex system, I mean, to help the law system. I mean, when we say that the future is distributed by hypothesis as was in the past, I think with artificial intelligence we can go past that, because the future is what our choices decide it will be in the real future. This is why it is not distributed as in the past. But artificial intelligence with natural language techniques maybe could shape the future in a different way from the past and learn from their own decision. I mean, I'm confused, but
No, I think
I
it's...
think all of these are rules at the end of the day,
Yeah.
but very, very complicated
Yeah.
rules.
So there are two ways of looking at complex systems: as a very complicated system. So that means you simply have very many rules, a very multi-dimensional system where if you change a little rule here, it will ripple through the system there. And you can say that's complexity, but in the end it's all about, let's say, strict rules. If you build a multi-agent system, for instance, that's how it works, definitely. But the whole point of people like Brian Cantwell-Smith is that that's something entirely different from how human beings, so individuals, but also human society functions. So he is saying, and of course he's not the only one, and he is a computer scientist, that with the current level of NLP, we're not going to reach general artificial intelligence. Now, we could speculate whether, in principle, it would be possible for these systems to develop their own goals, because that would need to be the case. Otherwise, there is fantastic work. I don't know if you know the work of roboticists Pfeiffer and Bongard. They wrote How the Body Shapes the Mind, I think. So they're roboticists, and they say if you want to have a real agent, a complete agent they call it, and if you want to build for that, you must build an agent that can survive in the real world, not in a computer server. And that has what, and I'm sorry, I'm a philosopher, what Spinoza called conatus, that is the wish to live and to push through your identity. So that a system which is artificially shaped has its own goals, and and changes those goals based on its own incentives, and is interacting with the real world in a way that allows it to survive. That would be general artificial intelligence. Now, my point would be whether that is possible, I don't know. I don't know. From what I read from computer scientists, I'm absolutely convinced that what we have now doesn't scratch the surface. It's in another league. It's not that if we have more of that it will come closer. It's a totally different animal. So I would say the jury is out, and we're now talking about legal tech. That's not general artificial intelligence, of course. Could it ever be done? Maybe, and then there are a lot of other questions like, what does it mean if there is this robo-judge, which has its own incentives, and who's getting extremely bored with us, because it is of the opinion that we're quite dense, in the sense of dull, and it has no incentive to keep us alive, right? So it will, if we're good enough, it will use us as slaves. And this scenario has been written about for centuries, right? Yeah. I find it boring, but it's good to remind ourselves that if you let something out of Pandora's box, it's not always what you hoped it would be. But I don't think it is interesting for a conference like this. Why? Because there is no such thing out there, and there is nobody who has an inkling at this moment how we could do it. At the same time, there are countries now that have completely artificial courts that make decisions, yes. And we'll hear about that in one of the papers. And we can have many discussions about that, and the discussion will probably erupt, but it has nothing to do with general artificial intelligence. So I think it's a fantastic question, especially at the moment when Virginia would be speaking, because I think she would be in complete agreement on this issue. It's what she has written and spoken about very often. But I think I can feel I'm not going to convince you. The question is here in the hall. It's going to stay with us. And I think for us lawyers who are not computer scientists, we must learn to understand that within computer science there are different understandings, different approaches, different methods. And what we have to do is to make sure that when we are rebuilding the law with the help of computer science, we need to take that part of computer science that respects the open texture of legal norms, for instance, and not a part of computer science that denies that. So you basically have just put part of the agenda of the conference on the table, and the agenda is that we need to face this and learn from each other. And so I'm very happy. And now we need coffee, and thank you. And the coffee break is going to be ending at 12:30 because I really want to start on time. So, yes, thank you.